You are listening to Lone Star Community Radio on 104.5 KCZW LP Conroe and 106.1 KZCC LP Conroe and worldwide on irlonestar.com.
Hi, welcome to the Legal Connection Show. I'm Toni Collins, an attorney in the Conroe area, and we bring you our show every Tuesday at noon to talk about issues that affect the community as a public service. You can email me, or actually you can contact us through, messaging under our Facebook page, which is the Legal Connection Show. And you can also listen to us on Tuesdays between noon and 1 on FM 106.1 or FM 104.5. Those are local radio stations. So if you get outside of the Conroe area, you're going to go into a different a radio band. But if you do and you're interested in what we have to say, then you can also go to irlonestar.com, go to the Legal Connection Show, and you can look at any of our past shows or listen to this one again. And we're also on YouTube, so you can just Google us that way. Today's show is going to be on how HOA laws are changing in Texas. Effective September 1st, Governor Abbott signed into law a number of things that affect HOAs, and HOAs are homeowners associations. They're also known as property owners associations or landowner associations. And Governor Abbott's been doing just amazing things. I love the new abortion law that he passed. I love that he is taking on the federal government about border control, and he was in the paper yesterday where President Biden's administration is saying they were gonna look into firing the men on horseback that were trying to corral the Haitians to not cross into the United States. And Governor Abbott said that he would hire them back. So he is just a renegade. I love that man. Anyway, so he signed into law a bunch of things that affect HOAs. And I want to add before I get into this that last week I was affected by another law that he recently signed in to place effective September 1st, and that was the gun control law, being able to carry a gun without a license to carry now. Those changed effective September 1st. And that affected a case that I had in court where I had a client who, during the freeze disaster, had a small pink pistol, might not have been pink, but in my mind it was pink, in her purse. And she was stopped for shoplifting at Walmart, which was not correct. They just were being falsely accusing her. And with good legal help, we were able to determine by their lack of evidence that they couldn't prove anything other than they were harassing my client. And so ultimately, what happened in the Montgomery County courts was that her co-defendant was exonerated off the docket, and it made no sense to me that my client shouldn't also be exonerated last week. We went into court. They offered my client the same deal with regard to the theft, that she could take an anti-theft class and then her case would be dismissed, but they wanted to keep her gun. And that was not an option. The gun cost a lot of money. It was her gun and she hadn't done anything wrong. I mean, we were willing to sort of, if they wanted us to take an anti-theft class just to get rid of the case to save money, that it can't hurt and didn't cost that much money, so that wasn't a problem. It was a problem that the Montgomery County law enforcement wanted to keep her gun, which they do a lot. And, you have the good cops and the bad cops. I don't know why that there's the thing about wanting to keep your gun, but they wanted it. And so we said, no, that was off the table. If it wasn't dismissed and she didn't get her gun back, then we would go to trial. And the reason that's important is because there's an exception to the gun possession law even before September 1st, that if there is a natural disaster that's declared by the state or the federal government, that as long you can have a gun without a license to carry, and I believe this is in other states too, if you're using the gun in a shelter situation. Well, hers wasn't quite a shelter situation, so we had a little bit of a gray area because there had been a natural disaster mandated, but Walmarts aren't actually a shelter. However, Walmarts are a shelter if you need a place to sleep off, some alcohol, or you need a safe haven, you need to get out of your house. Walmart, I believe, as maybe it's different for each store, but as a rule, will allow you to sleep in their parking lot because they're 24-hour. They've got security, and I was reading up on it. I thought, well, that could have been a shelter for her, and so we had a little bit of wiggle room for that. But we didn't do that. Instead, we said we wanted to set it for trial. Well, as luck would have it, I was talking to another. The lesson learned here is do not give up and accept no as your final answer. Because I was talking to another defense attorney that I'd known for like the last 20 years, a really good friend of mine, who happened to be in the court with me, and I was agitated by having to go to court on this, but I was setting it for trial. It wasn't something I was going crazy over. I thought, well, we'll go to trial and we'll win. It's just going to be more time that my friend has to be under the watchful eye of the government on bond. But what I was really talking to him about was another case that I wanted to set for a bench trial in Harris County, and how the prosecution was fighting me on a bench trial, which why would they fight me on a bench trial during COVID? I mean, that was just absurd, particularly when my guy has got, he's immunodeficient, and I had medical affidavits to support that he really couldn't go to NRG for a jury. So we're still fighting that. In that case, he agreed with me that I should get my bench trial. And when we approached on that case last week, the judge would not give me a bench trial because the prosecution wouldn't give me one because they knew that they didn't have a case and that they were just going to try to argue the Me Too movement to the jury. And so instead, the judge took it off the trial docket and put it on motions docket, which is just insane. So, the courts are just really unpredictable. But getting back to my gun case, what happened was I went after I talked to my friend. He goes, "Oh, no, you need to talk to the chief in this court because the second in command that you were talking to doesn't have the final word." And I knew that they didn't have a case in this Montgomery County course. I mean, they had no evidence. It was a false accusation, and they didn't want to give me my gun back. They were gonna try to force me into pleading because they thought I was lazy, which I'm not. So I went and I talked to the chief. I waited for the entire court to clear out. I waited until he had some time. He was still in the court. And I explained my case to him. And he agreed that the case should be dismissed. And so the lesson to be learned is don't settle for your final answer until you've fought a little bit, particularly if you know you're in the right, which I knew I was in the right in this case. My client was very happy. We had to do a separate motion to get her gun back, which is before the court right now, but she'll get it back. So the lesson learned here is or to be taught is don't give up on the first word. Even if you think it's the final answer, it probably isn't, and you should just keep on trying. And in my case, it was a pretty quick resolution that we got the case dismissed right there when I'd already set it for trial. So anyway, that was that. That was one of Governor Abbott's gun control laws, and you can watch one of our previous shows that talks all about what the new rules are effective September 1st. If you go to the Legal Connection show and you look up gun control issues. Okay, so let's go now to the HOA issues that just became law. A lot of laws changed. As you may know, if I have any listeners that have kind of know my background, I'm a board member in one homeowner association, and I think a thorn in the side of another one because I keep running for office, and they are doing everything within their power to find people to compete with me or not let me on these boards because I'm not really sure why. I think that it's because the homeowners association that I'm trying to get on the board, there's some board members that are intimidated by me, perhaps, or I really don't know because I've got a lot to offer. I'm getting my master's in land development. There wouldn't be any reason for me not to be an asset for a volunteer position. But besides all that, that gives me a different kind of perspective on these particular laws because on the one hand, I'm a board member and facilitating and helping the community of a 2,500 lot community try to make sure everybody, stays in line, and we're operating as a community, and like one body. And then on the other hand, I've got a much smaller community with about 90 lots who have got like the Gestapo that are the board members, that if you just can't get in. Yeah, so what you do is you just go to all the board meetings and you kind of keep up with the law, which is what we're doing now. All right, so if you've been on the receiving end of a homeowners association's notice that you are not in compliance with some of the deed restrictions or their architectural committee, then this show is for you. So here's the information you need to know. There are new realtor-supported laws that were passed in effective September 1st, 2021. They bring a more balance between the rights of property owners and their property owner associations, which is true. I believe that these are giving a lot more rights to the homeowners and taking away some of the Gestapo type rules of the homeowners associations, because homeowners associations were set up so that we could keep home values up, so that people don't have like purple houses and 5,000 cats, or parking 18-wheelers in their front yard, so that you can keep property values up. And the example was like in River Oaks in the 1920s. They were like one of the first homeowners associations, and of course everyone knows River Oaks is like one of the highly sought after, highly very, very expensive community to live in, because they've got such great rules that they enforce. Okay. And then you've got other communities that have fallen along the wayside because they've abandoned these rules and don't keep up with them. So consequently, when you have a few people that aren't complying and the homes become in a state of disrepair, it lowers the value of the homeowners around them. And so that's kind of what homeowners associations are supposed to do. They're supposed to keep everybody sort of together so your values stay up. More than anything else, that's what they're for. All right. So at least 6 million Texans are estimated to live in communities governed by property owners association. That's a lot of people governed by property owner associations. When you think of the vast number of ranches that we have that have no deed restrictions out there in Texas. This number will only increase as new communities are built across the state to meet needs of our growing population. Property owner associations are often necessary to create new housing, and they typically add value to the communities they serve, which is true. Property owners associations also have significant power over people's homes and their communities, and it's appropriate for the Texas legislatures to ensure that that power is executed with care, because they get out of control. My husband before we were married, moved out of a Sugarland community. I think it was Greatwood, because he would work on making Christmas decorations. And of course, he's a doctor, and so he was just doing this fun for the community. He would have his garage door open, and they told him that he could not work on these little wooden like Santa Clauses with the garage door open, because it was against their deed restrictions, which is absurd. How are you going to? I mean, you have 0 lots there anyway. So he got mad and sold his house and moved out here to Conroe to get away from that, and bought, we're on 12 acres now, 12 acres plus. We're, in a lawsuit right now to get some of the land that we own recognized to be titled appropriately under us. And we'll go into that in its entirety after we win our case, which we're going to. So anyway, he moved out here, and even though the homeowners association and our neighbors cannot see our house because it's completely secluded by trees, we're still getting backlash about non-compliance, which is absurd. So anyway, but if to kind of get back to if you are on this receiving end of a homeowners board that has nothing better to do than come after you for things that really are insignificant, that's really bad. And this should help you. The passage of monumental HOA reform legislation wouldn't have happened without the Texas Realtors. And of course, y'all may also know that I'm a licensed real estate broker, and they are very supportive in getting legislation passed that's favorable to homeowners and taking away the I can't even think of the term I want to use, the infinite power that homeowner associations give themselves through architectural committee mandates, which are not deed restrictions, which we'll get into in a little bit. During the legislative process, members advocated on behalf of homeowners and home buyers to show lawmakers the scope of issues being faced. Texas Realtors sent representatives more than 12,500 messages supporting the bill, a record high call for action and response. And that's because these homeowners association and the boards have got kind of out of control with their the power that they believe that they have, and they really shouldn't. When really all they're trying to do is keep homeowners' values up. They shouldn't be restricting everything you do and taking away the free use of your property. In addition, to the website, myhoastory.com has been a great tool for collecting real stories from homeowners and realtors about challenges that they have faced with HOAs. So just if you think that you may have an issue that's been addressed before and you want to see how somebody else has handled it, then go to myhoastory.com and you may be able to see how other people have resolved their issues that may not have been addressed by this legislation. The following changes were made by Senate Bill 1588 that is effective September 1st, 2021. And so these are just bullet points. All right, so fees are capped for subdivision information at $375 and updated resale certificates at $75. If you have owned your home for a long time and you haven't tried to sell your house, and this doesn't affect you at all, but if you have tried to get a resale certificate and it's over $75, which they have to issue to you if there's a homeowners association, and then this is important to use because they have to now lower that. Subdivision information at $375. I'll have to look into the actual law on that because if you go to, I believe it's the Texas Real Property Code 202, that's where you can find the backup to these bullet points that we're listing right now. Second, TREC, which is the Texas Real Estate Commission, will create a publicly accessible central database of Texas AOAs by December 1st, 2021. HOAs that have filed management certificates in county records before December 1st are required to file with TREC by June 1st, 2022. So within the next 6 months to a year, there'll be a central database for all HOAs, which I think is great because right now it's kind of hit or miss. You have to drive by to see where they're located. And you can find a lot of them, but the central database should be able to give you a map where you can highlight the subdivision and bring up the covenants and the deed restrictions. And I might add before I go down the rest of this list that, when I get asked questions as a board member, as an attorney representing a homeowner, or even representing a board, when I am asked a question about a deed restriction, the very first two things that I look at are critical because they are going to be sort of the contract that overrides and governs the questions that people ask me. The first place I always go is to the subdivision plat that was filed with the county. You can go to the county clerk site, log in as a guest, and go to plats and put in your subdivision name, and you can pull open pull up and open your actual subdivision plat that was filed with the developer. And it within that plat, it will show you many of the building line, well, not many, but where the building lines are, where the easements are, if there is any ambiguity with the way it's discussed, if there is something in there that prevents you from using or accessing a particular street that connects to your subdivision. There's a lot of things that govern your subdivision in that plat. It's critical that you look at that plat first because that will be, I believe, even overriding to the covenants because it's filed with the county and approved by the commissioner's court. So the first thing you want to do is look at your plat. And when you pull open the plat and you can download it onto your computer, it's really tiny unless you download it, and then you can use your Zoom feature and then really look in a lot of detail to what the easements are called, if it's a utility easement, if it's a drainage easement, if there's some ambiguity, if you can fight your battle with that. Look at your plat first to see what your position is. When you bought your house, you bought it subject to the subdivision plat, so you want to look at that. The next thing is you can pull open also in the Montgomery County Clerk's file, in that same area but not under plats, you can pull open the covenants and any amended covenants. You can even look to see whether your homeowners association board has granted any amendments to particular owners, which they have to do in writing with regard to giving them a waiver, giving them any special provision that's not allocated in the covenants that had to go and ask for. So you can look to see if your neighbors have got any special treatment, or if any. I guess if you want to go a step further after you read the covenants, you could actually go into the district clerk's district clerks file into the district court, because that's where land issues are argued, whether it's some ambiguity with regard to the covenants. You can put in your homeowners association. It's kind of hard in Montgomery County because if you don't have it spelled exactly right, sometimes you don't catch these lawsuits. But you can look at that too. So those are the first three places that I go. Is I'll look at the plat, zoom it, make it big, see if I can answer first, kind of get understand the facts of the question. I go to the covenants. I usually don't go to the ACC guidelines because those are made by the board. They're not voted on by the people. I don't give a lot of weight to them. The board can pass them, and in the very next board meeting, they can take them away. So that's sort of very subjective, whereas the covenants, the plat, and any rulings of the court with regard to your subdivision are in the courts with regard to how the courts are ruling on the way the statutes. I go look at that. Those are the first three things I look at, and then I focus back in on the question to see where it falls after I've learned those facts. All right, so but that's kind of a hierarchy of what you want to look at. Okay, so go back to our bullet points. HOAs are required to maintain websites with management certificates, meeting information, and notifications, because it used to be before we were digital, before we had the internet, going back 20 years, websites weren't required. Now there's statutes and laws that require that every HOA has to maintain a website, and they have to post when the meetings are, and they have to have those covenants available to you. The next one is HOAs are required to file dedicatory instruments with the county and provide certain contact information on all dedicatory instruments and management certificates. And that's what I was saying before, was that the covenants must be filed and in writing with the county. But the new law provides that also has to be posted, the most updated covenants, on the HOA websites. All right. So if you're looking to buy a property in a particular subdivision, then that developer has to have a website, and you can go look at those covenants. Before you buy, please look at your covenants, because you don't know what you're going to be prevented from doing. You may have an idea that you want to have 3 pit bulls, and your deed restrictions may limit you to 1. It may limit you to a lot of things. We're going to go over some of the things they can't limit you to in a few minutes. But here are the bullet points of what was passed for September 1st for this year. The next one is property owners have new protections from negative credit reporting when a fine or a fee is in dispute, and the HOAs are required to give a detailed report of charges and offer a payment plan before reporting delinquencies. So if you have been found to be in violation of a deed restriction, you can't be automatically reported to a credit bureau until certain procedures have been followed by your HOA. So know that, and we'll be posting those on our website if you want to look at those. The next one is the new law prevents some conflicts of interest within the HOA architectural review boards. And the first one that comes to mind is you can't have a member of the board on the architectural review committee. No one within his or her household, or if they're the spouse of that person, can be a board member and on the architectural committee. That very thing was being breached. It was biased. It was it lacked I guess, transparency, because in our own subdivision, we had a board member who was also the president of the Architectural Board Committee. So, how can you have a small group of people that are governing your board that are also telling you what your deed restriction violations are? So that effective September 1st had to be changed. And of course, the board appoints the people that are on the Architectural Review Committee. And in my subdivision, they appointed everybody that was in their inner circle where they have drinks together and, are on golf carts together. So it didn't change a lot. It was the same group, but at least they complied with the law. So you still have to sort of get around the, I don't know what the term would be, but I guess that sort of cliquish junior high type situation you've got in these homeowners associations. All right, so the next, and you can do that by attending every meeting and being on your toes when things are passed, and documenting those things, and then of course running for the board if you can, if you can get enough people to rally behind you that will actually vote. Okay, so the next thing is HOAs are barred from requiring access to lease agreements and are only allowed to request tenant contact info and lease beginning and end dates. So if you've entered a lease agreement for your property, let's say you have it on an Airbnb, HOAs can no longer demand that and put it in the deed restrictions that you have to give them a copy of the lease agreement. They don't get that information. They're only allowed the contact information, the beginning and end dates, not all the information that's sort of within it. And this is new, effective September 1st. So you have more privacy now. Next, HOAs are required to solicit bids for any contract for services over $50,000. That is huge. If you've got an HOA that's completely out of control and using the fund that they've collected for their drainage projects, their road projects, their gate projects, anything. If you've got like a River Oaks that has a ton of money and they're billing too much because they don't really have anything they're spending it on, even their, the mowing projects, they can no longer enter a contract without soliciting bids within a certain with a certain hierarchy of procedures they have to follow per Governor Abbott's new law. Next, HOAs are barred from prohibiting certain pool safety enclosures, the installation of certain security measures on an owner's private property, are certain religious displays. And we're going to go into that in a little bit. They can't, no matter what it says in the deed restrictions, now the statutes are allowing homeowners more freedom to use their property and, have their own pool safety enclosures, security measures, and religious displays that before may have been prohibited by your deed restrictions. That's huge, that the homeowners association can now tell you how you can use your property or prevent your First Amendment rights for freedom of speech. The next is HOA boards are required to provide members with timely notice about the meetings. I mean, pretty much of them, the HOA boards have done that anyway, but now by law, they have certain requirements that they have to meet and be, and they're going to be held accountable for, or anything that goes on in that meeting cannot be passed and it'll have to be reset. Next, the new law improves the due process in dispute resolution and provides additional legal avenues when seeking resolution with a dispute with an HOA. So if they come, if the HOA is coming after you for a deed restriction violation that is ambiguous and is not a real violation, you now have more avenues within due process to argue with them before they slap a lawsuit on you and you have to go to court. And, it's a lot of leverage when a homeowners association says we're going to sue you and they slap a lawsuit on you and you have to hire an attorney to defend yourself for something that they know that the courts will fall back on in line with the HOA 9 times out of 10 because they're like the 12,000 pound gorilla. But and then you're just trying to not make ends meet. You want to put your money into childcare or gardening. You don't want to be fighting a ridiculous homeowners association accusation, which doesn't have any weight. So now you have more dispute resolution avenues to work with. Okay, so that goes to our next topic, which I'm reading from the Texas State Law Library under Property Owners Associations. And if in doubt and you don't want to hire an attorney or you can't afford to hire an attorney, if you have some questions about your rights as a homeowner, do go to the Texas State Law Library. They've got a frequently asked question section, and they also have free legal aid, and you can call in and literally ask them a question. A lawyer will answer better than this show. I mean, you'll get them right away. If you call, they'll put you on hold just for a few minutes, and you can ask the questions directly to the law library. And wonderful facility, your tax dollars being put to good use that very few people know about. So please utilize that service. All right, so what are CC and Rs? I mean, if you've ever heard that sort of slang used, they are covenants, conditions, and restrictions, popularly referred to as CC and Rs. They're the rules that govern life in a property owners association, and Texas law uses the term also restrictive covenants. All right. So what can CC and Rs govern? Whether or not a property owners association can fine an owner will depend on the declaration of covenants, conditions, and restrictions, your restrictive covenants for your neighborhood. So if you've been threatened with a fine, this is where you go. You go to those restrictive covenants, which we now know should be easily accessible to you on your homeowners association website. State law does not specifically talk about whether an association can regulate non-political signage, parking issues, and architectural topics like paint color and mailbox decoration. If you have any questions about these kinds of restrictions, you will need to refer to your covenants. In other words, statutes will tell the homeowners association what they cannot restrict you from. But if it's not governed by the statute, then you have to go to your restrictive covenants. And even then, if they're not written well, there may be an ambiguity because it's not described properly. Like we have a situation right now in our own subdivision where they're telling us that our driveway needs to be paved, when the reality is we have a lot that doesn't have a driveway. It simply has an access for us to access the lot in order to determine, to do testing for soil, determine what we want to do with that. There's no other access. So the county required that we put a culvert in, which they put in. We didn't. And now our homeowners association wants to, I guess they're threatening to fine us unless we put in a 25-foot cemented culvert permanent. And we haven't decided if that's where we want to put it or what we're going to do with it. So the question is whether what the definition of driveway is. Well, there is no definition in our covenants. And so if there's no definition by law, you go by the sort of the commonly used definition and by Webster's dictionary, or if there's any legal precedent set for the definition. And in our case, there is not. But the legal definition by description provides that it's not a driveway. So we're going to win this argument. But you need to stand up for your rights. You're just not going to kind of fold over and do nothing. You can do this even by calling the Texas State Law Library. They can guide you in this way if you don't want to hire an attorney to give you what your defense arguments are if you're up against a homeowner association that you feel like is treating you unfairly. Now, Texas law does contain a few limits on what an association can prohibit. There are exceptions and exemptions for each category. So read the law itself in complete detail. I'm going to go over just those particular categories. So if you fall into one of these, you can look them up. Chapter 202 of the Property Code states that property owner associations cannot prohibit but can regulate the following. So I'm going to give you a list of 7 things that they can regulate but not prohibit. And they're important. Important, I guess, to you if it affects what you're doing. And which I didn't think this one was important, but rain barrels, composting systems, efficient irrigation systems, and drought-resistant landscaping. You can find how those prohibitions may affect you under Texas Property Code, Chapter 202.007. You can just Google it, and it'll come right up to that, and it'll tell you what the specifics are. And I'm going to give you an example here in a minute of 2 of the topics that I brought up that affected me recently. So I pulled them up. Another one is solar panels and solar energy devices. This comes up when people want to put solar energy devices on, let's say, their barn, their garage, something that might not be I guess it doesn't correlate with the way the rest of the subdivision roofs look. And so the homeowners association wants to prohibit it. Maybe it's not on the roof, maybe it's in the lawn, and they cannot prohibit your solar panels and solar energy devices to the extent that they must comply with Chapter 202.010. So if you're having that issue, go look that up. I haven't looked into that one, so I can't tell you a better example of it. No one's even asked me to look it up for them, so I'm not sure if that's a really big issue in Texas, but it must have been because the legislatures actually put that in the new bill. Another one is wind or hail resistant shingles, are shingles that are heating and cooling efficient. The homeowners association cannot prevent you from putting these new shingles on by your roofer because they don't believe that they comply with their color codes or whatever. But do look at section 202.011 because it may be that they can, because there's a statutory exemption and exception. So go look at that. This one I see a lot, but I haven't seen any cases against it. The homeowners association cannot regulate your display of the American flag, the Texas flag, or the flag of the United States Armed Forces. And this is under section 202.012. There are some regulations, and I don't have that in front of me. I think you can have one. The pole can be so large. I don't know what they've changed it. But if you have issues with wanting to fly an American flag and put a pole up in your front yard, or the Armed Services flag, then you should be able to look at section Texas Property Code section 202.012, and it will let you know what your options are. I know we had some issues in our the homeowners association I'm a board member of, with people putting political signage out, not after the political campaign. They were very pro-Trump. There were some people that took issue with that, and they were arguing about it. I believe that that would not fall under the American flag, the Texas flag, or flag of the United States Armed Services. But I suppose that if they just had a mention of it on the United States Armed Services, you might be able to pull that off. But that wasn't the issue that we had. All right, so I've got one that I am going to read about. It's the display of religious items. And that's under Texas Property Code 202.018. And I'm going to read that particular provision to you that's been updated since September 1st, 2021, because as a lot of my listeners may know, I'm very Catholic. I go to Mass every day. I think that that prayer works when you feel hopeless, that if you have nowhere else to turn, that going to Mass and just giving it up to God He will actually speak to you if you listen to Him. And there was a saint. They have a saint that's. I guess they're what is the term I'm looking for? I should know, as I hear it all the time. But every day in Catholicism, there is a saint that is the saint of the day, so to speak. And last week, Padre Pio was the saint, and so they were giving a lot of history in his background, how he had the stigmata and all that stuff. And he was, canonized very early on, just like Mother Teresa of Calcutta was, who actually wasn't even of Calcutta. Mother Teresa was from, I think, from Croatia, but she that became a teacher in Calcutta, and since that's where she heard of God's direction that she needed to help the poor in India, that's how she became Mother Teresa of Calcutta. In this case, Padre Pio, what that actually means, pious father, was also not from, I don't think he's from Italy. I think he was from an Italian town, a lot of Roman saints, or Italian saints. Anyway, they were to make a long story much shorter, he has a saying that I just live by, and I think we should all embroider it into our pillows. And he says that if you're in a period of despair, that you should pray first. Hope. Always do not ever give up hope. So you want to pray, never lose hope. And the last thing was how am I forgetting the last thing? It was so important. Pray, don't lose hope. Oh, and don't worry. Because worry is if you could be worrying about nothing, I mean, you should just put it in God's hand. And if you're living a good life and you're following God's laws, you're following the Ten Commandments, you're serving other people, you're doing things without those 7 deadly sins, envy and lust, you're doing things for the right reason. If bad things are still happening to you, but you're doing everything with your power to follow the commandments, serve others, you're not doing things with the motivation of the 7 deadly sins, and things still aren't going right, then you shouldn't worry, because it's just not happening in God's time. And so Padre Pio's again, what you should embroider in your pillow is to pray, listen when you pray, because maybe God will tell you what you need to hear, to hope, never give up hope, because that's such a preeminent thing. We all should have hope. And then finally to don't worry, because worry is while it may be the catalyst for you to do something and to get going on something, it shouldn't rule your life, because you might die tomorrow, and if you don't want to die worrying, you want to die, thanking God for having another day and living this gift that He gave us. All right, so that being said, I have a mailbox that my daughter knocked down last year on Mother's Day, and my husband was kind enough to rebuild this mailbox in the same dimensions. And as it was going up, for some reason, he was inspired to make it look like Notre Dame. So our mailbox has got 2 bells in it. Quasimodo. It's done very well. It's got the lights that come on at night. It's got the rose-colored window that we ordered from Europe, and we put it together. And so we have this beautiful Notre Dame mailbox. And to make it authentic, not just the rose-colored stained glass and the huge bells with Quasimodo and all that stuff, I bought small saint figurines that are 2 inches each, and we put the saints around the outside of it, just like in Notre Dame. They've got actually, I think they're actually royalty, but on my mailbox I've got saints, and so I've got maybe 20 different saints. I've got Padre Pio and Saint Therese. My favorite saint is Saint Philomena. Mary. And various other ones out there. It's a very small, and it's not obnoxious, but it could be regulated by my homeowners association. Here never said anything, because it was done so beautifully and so well, thanks to my husband and all my hard workers that came out and were able to put this beautiful mailbox together, which my heart melts every time I go home and I see my mailbox. But all right, but here are the rules. There's now a statute in place effective September 1st, 2021, that would prohibit my homeowners association, had they brought this up, to not allow me to have my Notre Dame mailbox if it was just for this purpose, to have my small, religious figurines to decorate my Notre Dame. We've got St. Joseph's that I bought online that are 2 inches, that are free to anybody that would want them, because I think everybody should have a St. Joseph that protects their home. But here is the law. It is Texas Property Code, Section 202.018. So it's the 18th part of this, the code. And it says, except as otherwise provided by this section, property owners associations may not enforce or adopt a provision in a dedicatory instrument, that's your deed restrictions, including a restrictive covenant, we just talked about those, there's a CC and Rs, that prohibit a property owner or resident from displaying or affixing on the owner's or resident's property or dwelling one or more religious items that display the display of which is motivated by the owner's or resident's sincere religious belief. Okay, so that's what I have. I have my Notre Dame, and I think that the saints are there to help you. I believe that God has helped me in many a trying time, particularly my clients. I pray for them all the time. Everybody needs a rosary. A&M needed a rosary this weekend, but I'm going to hand it to Arkansas. They played really well, and they were right on target. So I'm going to give kudos to Arkansas for their play and I think we could have brought a better game to Arlington, but we did not. So hopefully next week we'll have learned our lesson. All right. So the B section of this property this statute is this section does not prohibit the enforcement or adoption of a provision in a dedicatory instrument, including a restrictive covenant, that, to the extent allowed by the Constitution of this state and the United States, prohibits the display or affixing of a religious item in the owner's or resident's property or dwelling that. So here's where they can stop you. Threatens the public health or safety. So you can't have something like, if you're practicing weird religion where somebody's got a gun out there and, or a pit bull that would hurt you or something. So can't threaten the public safety. Can't have a religious display like that. Number 2, violates a law other than a law prohibiting the display of the religious speech. So you can't have, something out there that would, threaten somebody, or I can't think of a law that would violate unless maybe there was a safety issue of some kind. Hasn't come up yet. I don't know why they put this in here, but there may have been somebody that had a religious provision that would violate a law. 3, contains language, graphics, or display that is patently offensive to a passerby for the reasons other than religious content. So you can't put up a cross and, hang, something off of it that would be completely offensive. And we all know we're going with that. So you can't do that. That's against the law. Or is installed on the property in these two situations. Installed on a property that is owned or maintained by the property association. So you can't put a religious fixture in an easement or right of way that's owned by the property association, or is owned in common by the property owners association. All right. So pretty much you just can't put this display up in an easement, because that would be sort of a common area. But you can put it on your own property. Number 5, can't violate any applicable building line, right-of-way, setback, or easement. So you can't put something out there that's going to be prohibited from what's set out in your plats, okay, the building line, right-of-way, setbacks, or easements. But you can put it behind that. Certainly, there wouldn't be any reason to have some beautiful display of Mary up in your trees, I suppose, or something like that. Number 6, it can't be attached to a traffic control device, street lamp, fire hydrant, or utility sign, pole, or fixture. So you can't hang your religious symbol, Christmas tree, something on a traffic light if it happens to be in your front yard, or I guess anything that had to do with traffic control. And that's it. So it sounds to me like you can pretty much put a massive cross in your front yard, or backyard for that matter, and nothing is going to prevent you from displaying your religious preference. But this has changed from the way it was as of September 1st, because the way it was before was it was limited to like a Christmas decoration in your front yard by your front door. Now it's not limiting the number or the size of or where it's located, other than what we just covered, for to have your religious freedom, which I'm just thrilled with, because I've in our lawsuit that we have against a developer, I didn't really know, because I knew that they were in the wrong. They were claiming ownership to property that we actually have the title to, from sovereign all the way back to. I didn't know how to notify the people that were building behind us. Not that I really cared, but developers don't have to disclose to people that they sell houses to a lot of things, including title defects, which is just crazy. You would think that would be something that they would be required to tell you about, but they don't. There's a little provision in the law that says developers don't have to disclose title issues, or if there's a lawsuit pending. That's insanity, but they have a big lobby. And so I thought, well, how are these people going to be protected when we get their land back in this lawsuit and there's already a house on it? And so I thought, so I prayed about it, and the solution was to put beautiful pictures of Christ and the Virgin Mary, and just have an art gallery in my backyard for where they had taken all the trees down, which is what I did. And they were beautiful, and I still have them. And so now I know that I have there's nothing that's going to prohibit me from displaying Jesus, the Prince of Peace. And that's the peaceful way, something that is not offensive but beautiful. And we got many, many compliments on these beautiful pictures. So I'm really happy that the law, maybe somebody passed this law on our behalf. So, but what that also tells you is that I just read you a provision in the Texas Property Code that actually reinforces the bullet points that I was just giving you. And that's where you can go look to see if there's any provisions that prevent you from doing certain things or allowing you to do more than what a homeowners association board member or someone is telling you. All right. So go back to the bullet points that where the statute has changed and what they can govern. Moving on from religious items, another one is that they can't. A homeowners association can't prevent standby electric generators. And you want to look at Section 202, Texas Property Code 202, Provision 19 to make sure that there's not some exceptions to that. The next is swimming pool enclosures. And I don't even know what that entails until I read Section 202, Property Code 202 at Section 22. So I don't know what's there, but it may be slides or zip lines or something. I just have no idea what they're preventing there unless there's a chain link fence and they don't like the idea that somebody's put maybe a fence around their pool and they want to stop them because pool enclosures would prevent children from falling in. So I don't know what that would be. I do want to talk about two other things that are in this law. This chapter, which is Texas Property Code 202, also states that a property owners association can neither prohibit nor regulate the following: possession of firearms or ammunition. That's in 202, Section 21. They can't prevent you from having a multitude of things that if you weren't otherwise prevented, like you're a felon or something, they now can't stop you by their deed restrictions from having certain things that are not prevented for you to have by law. So your Second Amendment rights are widened here. You can't have a homeowners association that's preventing you from having these things. And the one that I want to talk about also, which I think is kind of fun because we had this on a different show, is lemonade stands. You wouldn't think that would be a big deal, but apparently if your child in your upscale subdivision in the Woodlands or neighboring communities that are just as upscale wants to have a lemonade stand, and maybe your next door neighbor is averse to this because it's not as beautiful, or maybe they don't want competing lemonade stands, there is now a law that went into effect on September 1st, 2019, but I think they've updated it, that homeowners associations cannot prevent you from having this. And so I want to read it because pretty much your kid can have a lemonade stand without having to get a permit, which was what they were using before. The police were coming out saying you have to shut down your lemonade stand to your poor kid that is just learning how to set up his lemonade, and learn commerce. If you go to lemonade stands for kids in Texas, we had one of the people that had set up a facility for kids to learn how to set up stands and to learn how to do the business, to set it up, the advertising, to get the websites. And it was a great facility, and I cannot remember the name of it now, but if you say Lemonade Stands Texas, there is a facility that will help you, a nonprofit, your kid be able to set up and do these just amazing Charles Schultz lemonade stands for your kid that are phenomenal. So do look that up. But here is the law that prohibits homeowner association from preventing you from being able to do this. Okay, so it's in Texas Property Code, Section 202, the Section 20.020. Certain sales of beverages by children. And the statute reads, a property owners association of a residential subdivision may not adopt or enforce a restrictive covenant that prohibits or regulates, including by requiring a permit or fee, the occasional sale of lemonade or other non-alcoholic beverage from a stand on property located in the subdivision by an individual younger than 18 years of age, who has the permission of a property owner in the subdivision for the sale. So in other words, this child doesn't even have to live in the subdivision. It can be on the corner, and as long as someone in the subdivision, but most likely the owner of the property where it's located can sell lemonade, put a lemonade stand up on a corner in your subdivision. The Property Owners Association does not owe a duty of care to the persons participating in the beverage sale. So they can't say, well, you can't sell it because whatever you're selling is going to make somebody sick. Bad argument. It won't work. It statutorily is not an argument that will fly. Second, it is not the homeowners association is not liable for any injury to the person participating in the beverage sale, except for willful or wanton acts or gross negligence of the association. So if the association, in any way, makes it so that somebody is hurt by making them move the lemonade stand so that it's in a bike lane or something, then they will be liable for it. But anyway, so your kid can have a lemonade stand, and it doesn't even have to be your kid. You can let somebody open a lemonade stand and put it on your property, and as long as they're under 18 and it's non-alcoholic, and it's just occasional, it's not a stand that's going up all the time, according to Texas Property Code 202.020, they can have their lemonade stand now because there was apparently they were getting some backlash. The kids were by a homeowners association just being mean is what it sounds like. So next week we're going to talk about architectural review committees, non-judicial enforcement of restrictive covenants, and self-help remedies, including being able to sue your homeowners association for a declaratory judgment before they sue you if they accuse you of violating a deed restriction, which you know is just you're not violating. So we're going to go over how you do that. And we are going to talk to you again next week. Remember to serve God by serving others, and we will see you next week.